Hello and welcome. My name is Ali. I'm the owner and founder of Goff Legal. We do estate planning, trust administrations, and probate in California. The question I get from a lot of people is, now that I have a trust, what happens if I get new assets? Do I have to come back and see you? Do I have to pay you again to update your trust? Usually the answer is no. Look, I just saved you a boatload of money. The good news is, with most of the trusts that we draft, and obviously you need to consult with your attorney to make sure that this is actually the case for your trust, but the ones that we draft often are revocable. They can be changed at any time. Usually within that, you can add and take out assets at any time. So if you're a single person and you have a trust and you had a house and we put that house in trust for you and that avoids probate, let's say you bought a second home. Or let's say you sold that home and you bought a new home. The trust will allow you to buy the new home in the name of the trust, or sell this one and sell it to the new person. That's great. And you don't really need an attorney to do that for you because you can have the title company do it for you. We will do that for clients who, let's say they bought the house and they didn't know they were supposed to put it in trust, or the title company wasn't really understanding it. They'll contact us and we will go, yeah, give us the address, come on in, sign it, put it, record it, done, protected. Super easy. But the same thing goes with bank accounts. Let's say you change your bank accounts. The schedule of assets we have, you would literally just cross off the asset and say closed, put the date, and write the new one. First Citizens checking account ending 4546. That's not mine, by the way. I just made that number up. And add the date and initial it or something like that. Because your schedule of assets ends up being a roadmap for what's in there. But the most important thing is that the title to the asset needs to be in the trust. Writing it on the schedule is good. It's not the best. It will not necessarily avoid court. Going to the bank and saying, I need my account to be in trust. Here's a certification of trust my lawyer gave me. They will put it in trust. And when you look at that bank statement at the very top, it'll say your name, something, something, TTE or trustee, and it'll say the name of your trust. That's how you know it's in trust. And again, open a new business, put it in your trust. As long as you want it to be controlled by that trust, that is where the asset should go. If you inherit property and you're not really sure if it should go into a family trust or maybe a separate trust, whoop, stop, call us or your attorney and ask those questions. I inherited property. What should I do with it, right? Likely we would say, let's schedule a phone call. Let's schedule a consult. Let's dive deeper into this because this might have some bigger implications. So what we do for clients, let's say they get our estate plan done with us. 5 years later, they call and go, I have a question about my assets. There's no charge. I will answer your question. Half the time is, I moved. And I go, awesome. What's your new address? Let me update my file. Is your house in trust? I'll pull the deed. The house is in trust. Good job. You don't have to do anything. You're done. Just update your schedule of assets and off you go. Isn't that easy? Yay. My only quick caveat on that is if it's been, say, 5 years or more, probably a good idea to actually come in and meet with your attorney, look at your schedule of assets, look at your trust, make sure that it still complies with the current laws, and make sure it still does what you want it to do, because sometimes people change and things change and we might need to make some updates. So that's my advice on that and what to do when you get new assets.